First of all, John Sproat, who received his Master's of Law from Harvard Law School, specializes in labor, employment, and constitutional law. He's the author of the Employment Law Manual, member of the editorial advisory board of the Hiring and Firing newsletter, and was my counterpart on the Mactinger case. Julie Hannaford, who is a partner with the law firm of Borden & Elliott, whose practice is concentrated mainly in the areas of commercial insurance and matrimonial litigation. She's lectured at the University of Toronto and is visiting faculty at South Bend, Indiana, St. Paul, Minnesota, Boulder, Colorado for the National Institute of Trial Advocacy at Notre Dame Law School in Indiana. And of course, she's brought along her client, who will be introduced later. Finally, Mr. Justice Lissaman, who most or all of us are familiar with. And in my experience, he's a judge, and I'm sure most of us have seen this, who other judges turn to get recalcitrant parties to settle their cases. He's probably the best judge at getting parties to settle at pretrial that we've got, and that's why I asked him to be there. Now, I've learned a lot from Mr. Justice Lissaman personally, and I've written down my top 10 list of things that I've learned. First of all, never quote from your own book. Secondly, don't make your juniors work too late. Now, I've got to admit that one hasn't sunk in, but he keeps telling me. Thirdly, take the bus to work. You never know what you'll learn about life and, more importantly, the neighborhood. Fourthly, remember that human instincts are going to prevail as effectively or more effectively on a judge than some technical legal argument. Fifthly, study your judge carefully before starting a trial. Now, upon consideration, at the risk of making it too easy for counsel here, I'm going to stop there.
Is it my turn now?
It's your turn now.
Thank you very much. I want to congratulate myself. I think this is the first pre-trial that I was early for. I'm normally always late, and I apologize for that. All right, we're now pretend we're doing long service and long life. Good morning. Thank you for coming. Ms. Hannaford, you act for the plaintiff. Mr. Sproat for the defendant. I want you to know I've read your material. My gut instinct that I follow 99% of the time indicates that we better retire if we can't get this case settled. That's my preliminary feeling. My views on pre-trials are that they are important. They can save a lot of time. As you know, I've told you this before, I don't want any posturing. I believe a pre-trial is an exercise in ways and means of settling a lawsuit. I also believe that a judge should always give a recommendation. I tell my colleagues in the Martin room, where judges meet occasionally, that judges must give recommendations or they shouldn't do pre-trials. And they all look at me and say, "You're right, Doug," and then most of them don't. However, hope springs eternal. Now, Ms. Hannaford, are you ready to proceed?
Yes, but I wonder if I could raise a preliminary matter with you, Your Honor, and I've spoken to my friend about this. I agree that this case, like many others, is eminently capable of settling, but I have the superadded problem of a somewhat intractable client, and I might say that he has insisted on attending at the pretrial, and indeed insists on being here with us during the conduct of the pretrial, and I've spoken to my friend about it, but I'm in Your Honor's hands as to whether my client, Mr. Longservice, can attend during the course of the pretrial conference.
Well, thank you. My view is this. In civil cases, it's very rare for clients to attend, as you well know. If he's here, I'm prepared to consider him sitting in, but I would like to make sure he doesn't have any dictating equipment with him. he's not proposing to tape what goes on in the pretrial. Mr. Longservice, you don't have a dictaphone underneath your coat, do you?
No.
Good. I want you to know it has happened twice at 361 in the last year where people have brought dictating equipment in. It just mustn't go on. My own view is this. I've no objection to Mr. Longservice being here, provided nothing is done that will interfere with the free dialogue, the free discussion, and provided, of course, he doesn't participate. Mr. Sproat, what do you think about this?
I don't have any objection to him being present as long as he's not going to be disruptive.
You must understand, Mr. Longservice, that in this dialogue, we may say some things critical of you. Are you prepared to sit in, and even if things are being said about your character, are you prepared not to say anything? There may be things
Well,
said
I
about
don't see any
you.
reason why I should take any crap.
Good. Well, Mr. Longservice, you've helped me tremendously. I've made my mind up. I think we'll have you wait outside. Would you do that? Thank you very much.
Is my lawyer staying?
Your lawyer is staying.
I don't see why it's done behind his back.
I'm prepared at the end of the pretrial to possibly consider seeing you and your lawyer together. Keep yourself available, would you? Isn't he wonderful? I want you to know I asked for him.
He'll be back.
I'm afraid he will be. All right, now let's look at this case. Now, both of you have done very good pretrial memorandum. And the other thing that I would like to say, I'm glad that both you people came, because I'm having some trouble with busy counsel who prepare all the material and send juniors to pretrials. And I can tell you it's the view of the judges that unless the person who is in charge of the case comes, you're not going to achieve anything. So I just thought I'd mention that and tell you how glad I am to see you here. Okay. All right, you just want to give me a quick rundown of the facts regarding your client, Ms. Hannaford?
Yes, this is a situation where we have an employee who's not a management employee, but rather an employee who's worked in the mailroom of an insurance company for, in fact, it was 26 years at the time of termination. He was 58 when he was terminated. He was promoted to a low level, or the first tier of management, just shortly before his termination. He's 60 years old right now. The difficulty in this case, both, I suppose, both legally and practically, has arisen as a result of this. He was presented with a package by my friend's client that required that he sign a release following acceptance of the package, and he declined that opportunity. And following his decision not to accept the package, the defendant effectively cut him off, and he was without any remuneration of any kind until he applied for Employment Standards Act benefits, which ultimately, and there's no issue on this, was settled at the urging of an employment officer for the amount of $19,000, $18,998.
As severance.
That's right. So there, as I understand it, there's no issue or fight that's going to be raised over cause, but I think Mr. Sproat and I have agreed on the issues that are going to come up in the course of this trial, although I must say we haven't agreed on the issue of how we deal with the evidence that Mr. Sproat, I know, is going to want to advance most vigorously at trial dealing with performance.
Now, you've said that as far as you're concerned, and I will ask Mr. Sproat to confirm, and I've read his pretrial memo, but you said this is not a cause case.
That's right.
Is that right, Mr. Sproat?
Well, there's no allegation of just cause, that's correct.
In connection with us trying to work out what would be a reasonable notice period. Have you anything to say on that? Not talking about the amount of the notice period, but let's say the concept. And I'm of course referring to this point that you raised in your memo about near cause, something that we thought was dead years ago.
Well, there are 2 points that I'm raising, and the first one is what's sometimes referred to as near cause. And to be quite candid with you, I think in the views of many judges, it's nearly dead, but it's not completely dead. And it's still open to me in my submission on the law to introduce some evidence on that point.
Didn't you find an 89 Court of Appeal case?
There's a Queensberry decision in the Court of Appeal, and it is 1989.
What does the head note say?
It's a very brief endorsement.
I've brought a copy for Your Honor, actually.
It's a very brief endorsement. You'll see there's a passage where that particular panel of the Court of Appeal said that they would not rule that conduct short of just cause could never be relied upon as being relevant to the notice period.
And that, of course, is surprising in view of the Court of Appeal case of some years before. What was the name of the case where Mr. Justice Sheard, who kind of pioneered just cause, was overruled? What was that case, the Court of Appeal?
It was a decision of Mr. Justice Finlayson's. Was it Bohemian?
Well, maybe our father confessor, Mr. Levitt, will know the name of that
Helbig
case.
and Oxford warehousing.
And that was the case that kind of torpedoed the concept of near cause. So you're taking the view, are you, that lackluster performance by Mr. Long Service is relevant, are you?
I'm taking 2 positions. First of all, yes, that lackluster performance is relevant, but this case may be somewhat different than other cases in that, with the benefit of hindsight, my client, in a sense, was asleep at the switch in not warning this employee and getting rid of him for just cause. But the really uncontradicted evidence is that this employee's absenteeism, his lateness, his indifference to his job is such that if we'd given him notice, we probably would have had cause to terminate him during the notice period in any event.
Would you say, and of course I've had the advantage of spending a minute or 2 with him this morning, would you say that he was a trifle belligerent?
He was a trifle belligerent, and in fact, in the examinations for discovery, there's one incident where on a recurring basis, he was advised that certain packages had to be delivered. It was a matter of importance, and his explanation, and I'm actually quoting, is, when they start paying me better, I'll start doing my job. So in my submission, and I'm trying to be as practical as I can at the pretrial, in my submission, that evidence will be heard by the trial judge, given what perhaps is a narrow opening to alleged near cause, and I think a judge is going to be influenced by that, and I think Ms. Hannaford is dealing with a plaintiff who may be sympathetic in terms of his age and length of service, but who's not terribly sympathetic in terms of his personality and attitude on the job.
I take it from you that you propose to cross-examine Mr. Long Service on those aspects of his employment record. Is that correct?
That's correct.
Will you be taking some position on that?
Well, I'm going to be taking the position that that's quite irrelevant. And the flickering flame of near cause that appears to be adverted to by Mr. Sproat is just that. Cause is not alleged, and that type of evidence is wholly improper. I don't want to spend the entire pre-trial discussing, you know, that issue of admissibility.
No, but I wish to discuss it.
I can tell you, Your Honor, that my client, notwithstanding that he was rather excitable during the discovery, will be very well prepared at trial and actually will be quite sympathetic on that issue. But in any event, my position is that evidence is wholly irrelevant and really quite inadmissible. And I'm asking, in fact, for an order in that regard at this pretrial, as you saw in my memorandum.
Yes, and I think it's perfectly proper for you to seek such an order. My own view is, in view of the fact that in your pleadings you have drawn the attention of the court to the fact that your client was an outstanding performer and had a very good record of the company, it seems to me perfectly fair for the question of his lackluster performance to be raised. Now, I'm not the trial judge, and it's a practice that I have, particularly when we're so close to trial. I don't bind on a matter of evidence a trial judge, but I again point out that if you put in your pleadings that your client was a first-class employee, I think you're open to the allegation that he wasn't quite as good as you would like me to think or someone would like a judge to think. I also can tell you that most judges I know, when they sit home at night and they have to make that decision, usually think of notice periods in ranges. I know I do. You very rarely ever get me saying at a pretrial, well, it is 17 and a half months and 4 days. I just don't work that way. I'm more likely to say it's between 16 and 18 months. And that doesn't necessarily invite a sore-off, but it's like in personal injury work. Damages are in ranges, and that's all I'm going to say to you. I'm certainly going to, in this pretrial, take into account that perhaps Mr. Longservice was a difficult kind of guy, and that's all I'm going to say on that. What I do want to know is this. How many people did he supervise, Miss Hannaford?
It ranged depending on how many people were sick at any given time or on leave, but it was 7, basically about 7 people.
And what was his salary when he was terminated? It was
$38,000 plus $275 per month worth of fringe benefits.
And then, of course, there's this bonus that we're going to discuss in a few minutes.
That's right.
Would it be fair for me to say, and I like your input, Mr. Sproat, would it be fair for me to say that Mr. Longservice was at the low end of the managerial path?
I think it's agreed that he was at the very low end, and in fact, for most of his career, had not actually been a member of management.
All right. What do you say would be an appropriate notice period, bearing in mind that this is taking place at post-Cronk? What's your view on that?
Well, I've indicated the notice period in my memorandum to be 30 months, and I may say that I've been careful in what I've inserted in my pretrial memorandum because I didn't want to insert a number that was outrageously high for the purposes of trying to get into a middle range bargaining position.
What would you have been pre-Cronk?
$18, maybe.
And I assume Cronk is going to an appellant court, is it, Ms. Hannaford? What is the word in the street, of which
Well,
I know nothing about?
I understand that that's the case. Having said that, I find this is really actually almost on all fours with Cronk.
The interesting thing about Cronk, and I'm not sure it applies to long service, but Mrs. Cronk, or Ms. Cronk, was clearly a very deserving person. And I'm not sure long service is quite as deserving.
Well, Your Honor, if I may say, and I know that you've given me your ruling on the issue of whether you'll give an order respecting the evidence on near cause.
I'm negative on that, as you know.
Yes, well, that, actually, it was Mr. Eklund that drafted the pleadings. It wasn't me. And I might not have been quite so aggressive on the outstanding.
Well, he's such an enthusiast for his clients. I would expect he would do that.
Yeah. in any event, there is nothing to indicate that Mr. Long Service wasn't deserving, save and except for perhaps a rather lax management policy that wasn't after its employees to improve their performance. And I find it surprising that my friend is taking advantage of that very laxity in the management process. To say that near cause is relevant and that ought to reduce the notice period. And I'd be surprised if he's going to distinguish the instant case from Kronk on that basis.
Well, Mr. Sproat, what do you say on the notice period?
Well, with respect to the notice period, first of all, for the purposes of attempting to settle this, I've got a great deal of difficulty in thinking that Kronk has changed the entire world in which we live in cases like this, particularly having regard to the fact that everyone's observed Bardol for about 30 years, and the Supreme Court of Canada specifically approved the language in Bardol. So it's difficult for me to accept on a settlement that Kronk changes things very much. My position is that the company was probably at the low end of reasonable in offering 12 months. I think that there is a range, and in my submission, the range was 12 to 15 months, and with no disrespect to Ms. Hannaford, I have had some difficulties with her approach to this, and perhaps if Mr. Eklund had been dealing with it, we would have settled it because he's a deal maker.
Miss Hannaford will have her chance to demonstrate whether she is or not. What is your view then on the notice period?
Well, for the purpose of settlement, having said that it's within a range 12 to 15 months, and but recognizing that there are other views at the table, for the purpose of settlement, I would be prepared to recommend 15 months, but that would be less amounts paid to date on account of termination and severance pay, of course.
I think my view is, for settlement purposes, provided all these other little matters that we're going to discuss can be dealt with, I think my view is that 18 months would be the proper figure. Various comments there. All of you, and now I'm speaking to you as a class, all of you know how difficult it is to win in the Court of Appeal. The Court of Appeal often dismisses cases even though they themselves would have taken a different approach. I think it's quite likely that the learned trial judge may be overruled in the Kronk case, but you know, it's not high odds because most civil appeals, I think about 95% of them fail, don't they, Mr. Sproat and Ms. Hannaford?
A very high percentage, certainly.
I think my figure is 18 months, taking into account everything.
With no deduction, is that right?
We're going to discuss reductions in a moment. Without the issue of deductions, it's 18 months. Now let's move on to the next issue. Let's deal with the Employment Standard Act. Now both of you know that the law is in flux. There's a line of cases that say that there should be deductions, one of which is mine. There is a line of cases, I think by only one judge, very respected judge, Mr. Justice Gibson. I think he's made two decisions. One of them is Stevens and the Globe and Mail. We have found out here a couple of days ago that Stevens and the Globe and Mail will not be heard probably until 1996. What do you think I should do with respect to employment standards, Ms. Hannaford?
Well, I say this for the purpose of this pre-trial, and that is that if I'm in a position where the recommendation of Your Honor is 18 months, it will be an impossible case to settle if I also have to say to my client that netted out from that 18 months would be the amounts received by him to date. And I say that on the basis of the equities. That's the only money that he's had available to him. He remains unemployed.
He's had a rough time.
That's right, and he's 60 years old now. And I can tell you, and I appreciate that there's really, there are those two lines of cases, and I don't I don't know how that's going to be resolved by a higher court, but in order to deal with my client on this, I'm going to have an absolutely impossible time saying that he has to net out the pay received, the $19,000 received. That's all he's had, and he's not working, and there's no issue that he hasn't tried.
What do you say, Mr. Sproat?
Well, first of all, Your Honor, as you'll appreciate, I can't be influenced to any significant extent by the difficulties Ms. Hannaford will have in dealing with her own client. What we're talking about here is the severance payment, and in terms of the equities, my client happens to be caught simply by the $2.5 million threshold in the Employment Standards Act. If Mr. Longservice was employed by any one of the many companies around that happened to have a payroll of less than $2.5 million, we wouldn't even be talking about this. My position certainly is that the severance payment should be deducted, and I think it also relates back to the issue about the 18 months. In my submission, while I appreciate that 18 months is a bit higher than I was suggesting, if we're going to 18 months, then it seems to me it's logical to deduct those amounts, because I think that even if the Gibson line of cases is upheld by the Court of Appeal, I would expect that there would be some moderation in the notice periods that judges would award as something of a reaction to that.
You mean low range, high range, that kind of thing?
To come down to the lower end of a range as opposed to the higher, because for what it's worth, I would not think that judges would ignore the fact that people like Mr. Longservice have received 6 months' pay under employment standards.
Is it possible, and I throw this out as a possibility, you know, when we were dealing with the wait to have the collateral benefits issue resolved in the personal injury damages area, often we would just split the difference in terms of the collateral benefits payable prior to Radich and Bloomer and even after Radich. I mean, I'm prepared to recommend that, to try to fly that. That is to have a saw-off as to the deductibility.
I'm not going to give you my views on that issue until the end. I'm going to defer on the question of the Employment Standards Act deduction. I'd like to deal with this bonus issue. Bonus cases have caused all kinds of problems over the years, as both you know. My own view is that based on the cases, if it's a kind of an automatic kind of payment, and it's not a big figure in this case, but if it's an automatic figure, Mr. Sproat, I think that the plaintiff should get it for the balance of the year in which he was terminated, and I think he should also get it for the period of the notice period. If you can tell me that there was a real conjectural element in there, then I may think differently. But as I understand this one, this bonus was based on net profit of the business, isn't that right? And it was across the board.
Well, that's right. I can't argue to you that there was any element of discretion. There is no doubt that if...
or Longservice wouldn't have got a nickel, would he, in the bus, based on his belligerent attitude.
That's correct, yes.
That's what I thought.
So I can't submit to you that it's not based upon a formula, and certainly if long service was employed at the end of the current fiscal year and at the end of the next subsequent fiscal year, because that would still fall within an 18-month period, he would have received the bonus. Having said all of that, my position is that it's open to the parties to stipulate the conditions of entitlement to the bonus in the same way that they stipulated the formula for the bonus. And the stipulation of the parties was that bonus would only be paid to persons employed by the company at the year end. And I did bring to your attention the Brock and Matthews case, where in dealing with stock options, the Court of Appeal said that if the options are defined in terms of giving rights to employees, if you're no longer an employee, whether that's resignation, wrongful dismissal, or dismissal with notice, you're still not entitled because you're not an employee. So I'm relying upon the wording of the bonus plan as disentitling long service in these circumstances, notwithstanding that it was a termination without just cause.
I think that's a perfectly proper submission. My own view is to the contrary on that. And as I have often told you, you don't have to, at this level, pay the slightest notice of anything that I say. However, I'm saying now what I said 10 minutes ago. The bonus gets included in the calculation if I was doing the trial. What I want to know from you, Mr. Sproat, is this. Now, this is a man who's been with this company many years. I would like, and we are going to settle this. I mean, it's a foregone conclusion. I would like you to be as cooperative you can in what I call tax treatment. For example, is it $2,500 or $2,000 a year that we can put into an RSP if that suits him?
$2,000 per year.
Well, then he's going to do pretty well in that area. Maybe that will take care of it. But if there's not, then of course we have the fact that interest is, for some wonderful reason, is not taxable. Isn't that correct?
It's not subject to any withholding tax, that's right.
No, but I don't think the government expects people to report it in these cases. Now, let me just speak to our expert. What is the position on that, Mr. Levitt?
I understand you're correct.
I don't know why I'm correct, but I understand that I'm correct. All right, so then there can be a little bit of assistance to Ms. Hannaford's client in that area. So we've got the RSP and we've got the matter of the interest. I might tell you both, and it doesn't particularly apply in this case, but I don't believe lawyers pay enough attention to tax matters in this kind of litigation. I recently had a case where there were all kinds of claims. It was a wrongful dismissal case, but there was also a claim for damages for defamation. Well, we were dealing with big dollars overall package, and when we came to the end of it, we beefed up the pleadings a bit with an amendment, and then the case was settled, and there was a reasonable allowance. Nothing that would draw anybody's attention, nothing crazy, but there was a reasonable allowance to damages for defamation. And defamation damages are well known do not attract tax. And I can tell you now that I'm speaking to you as students here today, pay some attention to the tax angles, particularly on these big cases, or people get absolutely clobbered. So I expect you to be as cooperative as you can with respect to taxes here. Okay?
We'd certainly be prepared to do that, and we're late in the calendar year now. We could also split some payments into 1995 if that would be of any assistance.
I think that's a very, very good idea. What I like about you two here today is you appreciate that the only way we're ever going to settle the lawsuit if we make it practical from each person's point of view, and I like that remark.
And I must thank you, Your Honor, for facilitating that on behalf of Mr. Sproat.
Generosity of spirit always has a place in all my pre-trials.
May I also ask if in addition, Your Honor, would recommend that the shares which are owned by my client could be taken up forthwith as well?
Well, I think that is a first-class idea, bearing in mind that in matrimonial cases, we're now seeing, when we have a full-blooded matrimonial case, we now see corporate counsel hired to bring oppressed shareholders cases in Mr. Justice Farley's bailiwick at 145 Queen Street. I think you people will be nuts to have a minority shareholder around. So can I have your undertaking to buy them out for cash in accordance with the formula set out in the agreement?
We're quite prepared to do that. My client's quite prepared to do that as part of an overall settlement, yes.
Well, you see, that's also helpful too. There won't be any interest on that money. It'll be straight, whatever it is in accordance with the calculation. It's not a big item, is it?
No, I think it's $20,000.
Well, that's probably a big item to Mr. Longservice. Now, you've got a claim in here for damages, haven't you, for, is it punitive damages?
Well, Mr. Eklund claimed them in the statement of claim, and
Well, he's
and
a big shooter.
if we're proceeding to trial, absolutely, that would be our position, that this is a case for punitive damages. And you know, I should say, Your Honor, now that we've almost, it appears that we've, thanks to you, almost reached an accord with respect to this resolution. That's something that my client has actually fastened onto with great. He really looks to the trial to a judge to award punitive damages against this insurance company, which he feels has ruined his life. And you can well imagine that I shall have a significant selling job to do to my client, given, as you have probably guessed already.
Well, it's my view that judges, quite properly, are very chintzy with respect to punitive damages, unless the conduct of a corporation or maybe a person is absolutely scandalous. In this particular case, I think the offer was not a bad offer at all. In fact, the 12-month period pre-Kronk was, I think, right on the money. Where I have found tremendous trouble is when a check is put on the table and the employee can only sign it if they sign a release. I think that is a management technique that I deplore, and it always causes trouble. What should be done is that the employee should be asked to take the matter to his lawyer, take the documents, including the release, without the check, to his lawyer. And that's the way it should be done. That's my view there. I don't like coercive tactics at all. Having said all that, I doubt very, very much whether punitive damages would be awarded in this case whatsoever. As far as I make out, it's only tribunals who award very large sums for punitive damages, and I can tell you as a judge I have tremendous problem with that. Overall recommendation on this case would be to settle for 18 months. I would give a 50-50 adjustment with respect to the employment standard severance. I would deduct 50% of that, Mr. Sproat. I would like you to add up all the numbers and come up with one number. You don't have to do it now, and that's the number that should be put to Ms. Hannaford's client. Direct his attention away from the components, and that is my recommendation. As far as the trial date is concerned, you know how up-to-date we are in Team 2 at 361 University Avenue. You could have a trial on Monday morning. Are you interested?
Well, it might be of assistance for me in going back to my client if I had some better feeling for whether or not this is going to be acceptable to Mr. Longservice. I don't know whether it would be of any assistance to
Why don't we give Ms. Hannaford 5 minutes with your client, or do you have some instructions already?
Well, my instructions are 30 months, all the bonuses, none of the termination or severance, and all my costs. So I can tell you right now that I've got a significant uphill battle. I don't know if it would be of assistance for my client to have a word, or for you to have a word with my client, Your Honor. I'm in your hands. You can my client is actually resentful and concerned about what's gone on here in the absence of him. I mean, that's the problem that I'm facing.
I don't propose to see your client. What I would like you to do is to make an offer under the rules. He wants to see me?
He really does.
You bring him in for a moment, would you? Just bring him in. Wait.
This is more for my protection, Your Honor, than anybody else's. Unless...
You will be protected, Miss Hannaford. Do we need security? He's probably off having a drink. He's probably given up on you. Come in, Mr. Longservice.
Perhaps I'll let him sit closer to you, Your Honor.
Now, Mr. Longservice, I'm not going to tell you what the recommendation is. We've had a very good dialogue in your absence, and I have made a recommendation. And I want to say this to you. You're very fortunate to have a very good lawyer. Listen to her. And if you can't listen to her, maybe you should fire her. But she's a very lawyer if you don't take my advice. So then he says to me, how expensive would it be? And I said, $2,000 a day. And he told me to settle the case. And what I say to you is this. Spend a few minutes with Ms. Hannaford. She'll tell you the recommendation. In this field here, we don't deal with absolutes. This is not a 30-month case. It is considerably less than that, but there are some pluses. I have made a recommendation that will please you in some areas. I've recommended that you be paid out immediately for your share interest in the company as part of an overall package. There are some things that you would like. All I want from you is that you will listen to your lawyer, and then, of course, you can instruct your lawyer. Do you have anything to say?
I'd like to ask you a question.
Go ahead.
I was reading outside, and it says that I can have a hearing and get my job back. It says that there's a Canada labor code. I was looking at it. It says that they can have a hearing and I can get my job back. Can I do that?
I'm not dealing with a Canada Labor Code case. I'm dealing with a claim for damages by you, and I think it's unlikely, in fact I know it's impossible, for any judge of this division to give you your job back. We're looking at damages, we're looking at money.
You mean I can't, there's no way I can get back
Working
the company?
No, I don't think there is. Would you want your job back? Is that what you'd like?
I wouldn't mind having the job back. I mean, what else am I going to do? I got nothing to do.
Well, is that one of the things that's possible, Mr. Sproat?
Unfortunately, no, that is not possible.
It's all right. I wouldn't want to work for the bastards.
Mr. Longservice, thank you for coming.
And do I talk to my lawyer now?
Outside, just stay here. Thank you very much. I will fix a date.
Mr. Longservice was played by W. Ross Murray, who's a senior partner at Borden Elliott, doing real estate and commercial litigation, specializing in solicitors' negligence matters.
And I want to say thank you very much, Ross Murray. I've known him for many years, and when I was thinking about this last week or Saturday morning, it seemed to me that he'd be a natural. If anybody has any questions of me or anybody here, I think we will be very delighted to try to respond.
Do you want to take 3 or 4 questions before we disperse? Yes.
In a fictional situation, would this company be subject to Canada labor?
No.
Remember, there's no collective bargaining agreement here. I mean, this is a man who's hired without a contract. It's just a matter, he has no right to a job. It's just a matter of how much notice he's entitled.
Well, I appreciate that's the issue that was before the tribunal, but I just wasn't sure whether this federal or provincial legislation would apply.
2 more questions? Any other questions? Yes.
glad you got the right word, Mr. Singer. I see absolutely nothing wrong with these suggestions that you made. Damages are like the length of the British Chancellor's foot. You never know exactly what they are, and I see nothing wrong with what you did whatsoever. We call that the good housekeeping seal. I'm not to be quoted.
Well, thank you very much for your attention and for staying 15 minutes beyond the original allotted time. Have a good day and have a good afternoon for those who are staying.